let's talk a little bit about the format of the class first and take a look at the syllabus. So this is secure transactions. If you're not in secure transactions, you should not be here. No one's leaving, so you're all excited to be here. Great. My name is Lars Smith. I'm the Associate Dean. I probably had some of you in property before, maybe. You take property from me? Yay. Okay, good. Then you know I'm a terrible teacher. That was a joke. Good gosh, come on. I know it's the first week of school, but let's lighten up a little bit. All right. The first thing I want to say is I don't have set office hours. So that's because I'm usually in my office. So my invitation to you is if I'm in my office and the door's open, stop in if you have a question. Or set up an appointment with me. So I wanted to get that out of the way. Some people are guaranteed that they can be in the office. Unfortunately, in my role as associate dean, I end up being asked to go to meetings. Those meetings invariably are like scattered throughout the week, so it's hard for me to guarantee that I'm in my office at any particular time. However, if I'm not away at a meeting or teaching a class, I'm usually around my office. Always happy to talk to you about anything, all right? Now, we lost Jennifer DeSanza, and I'm very sad about that because she was a great dean of students and a wonderful colleague. As a result, I probably will have, until we hire a replacement, more responsibilities with respect to handling student issues. So the first thing you should know is you can come talk to me about concerns that you have. Professor Markuson is also available, so if you have concerns that of a personal nature that you want to have handled, he's not stepping into the role of dean of students. He's just available to help students with personal issues. But if the things that you have relate to academic issues, the schedule, things like that. Professor Arnold is the dean of curriculum and the scheduling, but once the semester starts, I take over the role of interfacing with faculty. So you're always welcome to come talk to me about any issue you have with any faculty member at the law school, adjunct or otherwise. So I handle those issues. But I also will be doing some more things like bar certifications and the like. So there are some responsibilities that are now in my office for the time being. When we hire a replacement, we will ship those back to the Dean of Students office. Let's see, what else? Oh, well, let's talk a little bit about this class. Normally is maybe not a good way to put this anymore. In previous years, I have taught this as a traditional doctrinal course. But the dean asked those of us who teach more of the required courses to think about if we could rework our courses and make them more online. So what I did with this class is not go totally online, because I actually think that it's very good for us to meet. But for this semester, the plan is teaching this as a flipped classroom. So what does that mean for you? As you saw from the materials that were available on the Blackboard page, I'm going to do lectures that are recorded about the substance of the law and put them online. The goal is that you will watch those before you come to class, work the Cali exercises that I'm going to post on the Blackboard site before you come to class, and work the problems in the book before you come to class. So you're going to spend a lot of time working through the materials in class. Then when we come here on Wednesdays, we're going to work the problems. So my hope is, and there's some good research that this actually does improve comprehension, that you will have done enough work outside of class so that when you come here, we won't have to spend time talking about, well, what is section 109 of Article 9? We'll actually get right into the meat of things and work problems. And if and I may from time to time come up with hypotheticals in addition to that, and we'll just work them through together in the class. My goal is that will help you learn about working, analyzing the law, learning how to read a statute, a complicated statute. Take that statute, understand how it theoretically works, take a set of facts, apply the law to those facts, and come up with a conclusion based on those facts. And that's what we're going to concentrate on in class, okay? I will have a discussion board available on the Blackboard site so that as you work through the recordings and the problems, if you have a question, I will look at that site. I also encourage you as classmates, your classmates, to answer those questions. So if somebody says, I don't quite understand how 1901D works, or 9109D, works, which is an exclusion section of 109. We'll talk about next week. I invite you to be part of that dialogue, but I'm going to look at that discussion board and be part of it and talk about it and answer questions you may have. So you can't see me in class and you just want to throw it out and say, hey, I listened to the lecture. I do not understand what you meant by that. Before class, I will be glad to talk about anything, but I'll be glad to talk about those sections. So I'm not saying we're not going to have the dialogue, it's just we'll do it through a discussion board, okay? All right, now, since it's the first time I've done this, we'll see how it goes, right? We have this room reserved for Fridays as well, and I have not canceled that. And I haven't done that because I want to see, is 75 minutes enough time to work the problems every week? And we'll see if that works. If it's not, then we have the ability to do an overflow, but we would never do that without notice to you that I would like to be available. I'm not going to require that attendance on a Friday, but it may be on occasion we will get together and talk about some additional stuff if I see that people are having trouble with things. Okay? So we're only going to be required to meet once a week, not twice a week, on Wednesdays, and that's it. Who here likes having Fridays off? So is anybody here pissed at me because I'm saying you don't have to be in the building on Friday at 10:25? It's okay. You can be mad at me. I have 2 daughters that are mad at me all the time. No matter how hard I try to do right by them, I'm an idiot in their lives, you know? I get that. I'm okay with that. I understand. It's an experiment. Your feedback is appreciated. So I will not take it personally if you say to me, this has been, difficult for me. Tell me that, because I'd like to make sure that if we do this on an ongoing basis, that this is a useful way to teach the class. But let me explain a little bit about what I come to understand as the research. One of the things that I have read about recently is that sometimes comprehension of material, when you're going over complex things in class, if you only hear it once, it really is hard to then learn it, right? You read it, you learn it, you hear it in class, and maybe you don't get it. So one of the nice things about the videos is you can do 2 things. One, you can listen to them faster or slower than they were recorded. And you can listen to them over and over again. Now, I can't promise you I'm going to be good about this, but my goal is for all of these videos to be shorter. So rather than having one big recorded lecture going for an hour, I'm going to try and break it up into smaller 10, 15, 20-minute segments so that you can listen to a particular topic, go back over that if you need to, and then move on to the next thing. All right, so let's talk about grading. There's essentially going to be 3 parts to your grade. Obviously, there's going to be a final exam. In this class, I do essay exams. I don't do multiple choice, and there's a reason for that. This class is tested on the bar. And if I haven't made it available, I will make it available. There's a subject matter outline for secure transactions provided by the multi-state essay examiners. And it sets out all the sections that they feel are open to be tested on. Since it's on the essay portion, I guess I don't feel like multiple choice is that helpful. I mean, first of all, multiple choice is not how life is lived. And in property, I give multiple choice questions because it's tested that way on the bar, in addition to being essay tested. In this class, I don't typically give multiple choice questions. The exam will be a collection of essays at the end of the semester. The problems that you're working over the course of the semester are like little mini essays. So my invitation to you is to write them out as much as possible. You don't do it in an exam. You don't have to do it as an exam type scenario. But I think the effort of working through the problem and maybe writing it out when you bring it to class will be helpful for you. So the exam is primarily, the grade is primarily an exam. But then there's also other components to the exam. There's going to be 2 short assignments I'm going to ask you to do that will be written out. One will be done by all of you. It's going to be a written exam, a written question that is going to be based on putting together a financing statement and a security agreement. Now, it's not going to be a full security agreement, but it's going to be the language that creates the security interest and then the language in the financing statement that goes with that. So that's sort of a practical, skills-based exercise that if you're doing secure transactions in real life, you have to know how to do that. The second part is I'm going to have everybody in this class write out one of the questions that are due. And I'll hand out a schedule of when you're due to write one out, but you'll hand it in. It'll be a few people every week, and you'll write out one of those answers. I'll read it through and comment on your answer. So that'll be a more full test, and I'll pick out a question that has more facts in it. I haven't got that list worked out yet. I'll hand that out. Probably I will start the third week of the semester when I'll start asking people to hand stuff in, so nothing for next week. And maybe sort of 10 or 11 weeks worth of stuff. So it'll be just a few people a week. Those two things each will be 5%. So the assignment that is a financing statement and a security agreement language, 5%, and the handed in work, a written out problem, 5%. Then there's also going to be points for the Cali exercises. So the Cali exercises are going to be, I'll put a link every week for the exercises that you're supposed to do for that week. My expectation for you is that you'll do them before you come to class. If you do them before you come to class, you get the points for having done them. I do not care what score you get on them, okay? They're there to help you assess whether or not you understand the material. All I care is that you do them. I don't care that you get an A. That part, you will not be graded on how you do the assignments. If you submit them, 10% of your grade. And then it's some variation. So if you hand it in before, I ask you to do them for the entire semester. I would hope that you would do every week's worth of Cali exercises. If you don't, it's 1 out of 14 weeks. Probably won't kill you. But to get the maximum number of points, you should work through the Cali exercises. Okay, there will be some weeks when there are more, some weeks there aren't as many. Okay. The casebook is not designed around the Cali exercises. So I will say now, occasionally you will get problems where you'll go, I don't think we've covered this material specifically. I can't fix that. The guy who wrote the Cali exercises didn't have this casebook in mind when he wrote it. I've tried to mirror them as closely as possible. Occasionally you'll be asked to look up a section of the statute that maybe isn't in the reading. Because it's not graded, I don't feel like that's unfair. And you learned a little bit more than was expected, right? So, if you see something, I don't quite understand it, always ask me. If you read something that you don't understand, send me a note on the discussion board, come in to see me. Happy to talk about any of the problems, okay? But I'm not going to say, well, I'm not going to count it. It's the effort of going through the problems that you get credit for, not how you did on them. So hopefully you'll get some diagnostic help that will help you figure out if you're getting, you're learning the material. Now, was there a question over here? I didn't know if you were raising your hand. Okay. The way I expect class to go when we are in session is we're just going to work the problems, and I'm going to call on people, and we're going to work them through together. So that's why I would suggest write them out before you come into class. So you'll have at least some notes about how we work through the problems. I'm just going to call on you, and we'll put some sections up on the board, and we'll work through the language together and make sure we understand how the problems are answered. Right? That's not graded. That's part of being in class. Questions about that? All right. I see extreme boredom on a lot of faces. That's exciting to me. Yay. Right? I have a challenge. Get you excited about the class. Are you excited about the class?
Yes, sir. Yes, sir.
Excited about the class? No, you're not excited. You're really not excited about the class.
Sure.
Indifferent. I get it. Right? If you're not going to be a business lawyer, maybe you will never use Article 9 ever again in your life. But I will tell you, if you have the possibility or at some point work with a company, one thing I guarantee you is they have loans. And if they have loans, they have secure transactions. Every business lawyer at some point in their life will have a client that borrows money, and that bank will ask for a security interest in the personal property owned by that company. Right? Not as common with individuals, but it does happen. But with companies, absolutely, I can guarantee it. So there are two reasons to take this class. One, it's tested on the bar. So there's a very good chance you're going to get a question on at least something to do with commercial law, and probably, or highly likely, it's going to be Article 9. They no longer ask questions about Article 3. So if they're going to ask Uniform Commercial Code questions, it's either going to be Article 2 or Article 9. And second, if you actually do practice commercial law, business law, I should say, there's a very good chance that you will do this in life, and you will have a client that will have an issue related to a secured transaction. Now, you don't need to have taken biz orgs to understand this class. There's no, there will be problems where corporate structure may be raised when you get a security interest in a stock, for example. But just because it's a commercial transactions class, you don't have to have taken biz org. If you have worked in the banking industry, anybody here work in the banking industry? Anybody do commercial lending?
I mean, I was just a teller, but
I was a teller too. I did that for a year. Did you work with loans at all? No. Anybody here ever work in a lending department? Yes.
Yes.
What did you do?
Well,
What kind of loans?
we did a lot of consumer loans, but I would say I was in the management training program.
Did they ever show you what a UCC1 was?
We have the loan department, all this is automated now.
Yeah, right.
I mean, the lawyers review the wording and whatnot that goes into the program, but yeah.
Yeah.
I've seen it.
So I went I became a consumer lender. 1987, I became an assistant manager at Security Pacific Financial Services. And that little hypothetical I put the video on there about the guy losing his bed, I did that. I took a guy's bed, right? Horrible, right? I actually drove to the guy's house and took his bed. Yes. So everything that happened in that video, I did it. That's why I use that hypothetical. So that's a consumer finance situation, but it was a secure transaction because we'll learn if you finance a consumer purchase, there's an automatic security interest created by that. If you're financing it with a security interest, that is automatically covered by the filing system. No documents needed. You just sign the security agreement, and the bank has a security interest in the property. Purchase money security interest in consumer goods automatically perfected. And I just used a bunch of words. You're like, what? I get that. Okay, that's powerful, right? That the bank can go to somebody's house and take their stuff without going to court. I didn't need a judgment. The guy did file bankruptcy, and I went to the bankruptcy hearing, and the judge was about to gavel his debts discharged, and I raised my hand and said, "What about my bed?" And the magistrate, I was a magistrate actually, he looked at me and said, he goes, "I financed the purchase of his waterbed." And the magistrate looked at him and said, "Well, what do you want to do?" And he said, "Well, I can't afford it." So he said, "Okay, well, give him back the bed." Turned out he was the nicest guy I'd ever met. He actually took the bed apart and loaded it into my car, and I drove away with his bed. Turned out we sold it for maybe $70, right? He owed like $500. You can't sell used mattresses. I did not know that. If I had known we were going to get $75 from this, I would not have taken his bed. Okay? But my boss was so happy with me. When I said, "I just got the guy's bed, it's in the back of my car," she goes, "Great." Right? People have to know that we will do this. Okay. I applied to law school shortly after that because I felt like such a jerk. I hated that job. So, it does come into practice. The UCC one I was asking about, that's the piece of paper that you filed to perfect a security interest. When I was working at this company, they showed me that here are the UCC ones. So I went to law school thinking that the Uniform Commercial Code was a single-page document. I went to law school. And then I showed up in contracts, and I purchased this. And I go, "You got to be kidding me. This is a big deal." All right, so let me take a second to talk about the material. This is the book. This is the first time I'm using it, so I think it's a good book. I've heard good things from other professors. I've been reading through it. I like the problems. It's a problem-centered book, which I love. I think that's a really great way for us to work through this material. There's 140 problems in the book. In the syllabus, I have assigned the problems that you will do every week. You'll see that on the back page. As you read the materials, you work the problems, okay? On the videos, I will talk about the law. there are cases in this book. The cases are for illustration purposes only. They rarely ever provide a true insight about the law because the law is in the statute. We are going to learn how to read a commercial statute. We're going to learn how to cross-reference sections, find definitions, things like that. That's what we're going to learn how to do in this class. So this problem will give you the sections of the chapter of the code that you should look at to answer the problems. So when you're reading this, you should have this. Now I assigned some version of this one, and I love this one because it's thin, but it's not comprehensive. It has Article 9, Article 1, and the Bankruptcy Code, the relevant sections of the Bankruptcy Code. I don't care which version of the code that you get. You just need a printed one. This is the one that I use as a law professor because it has everything. All the articles, plus the Bankruptcy Code, and the Consumer Credit Protection Act, the Federal Trade Commission Credit Practices Regulations, Federal Tax Lien Statute, Bankruptcy Code, et cetera, et cetera. You don't need most of that. But if you purchased a version of this, a bigger version, great, bring that to class, okay? We're going to, and let me just explain why I think you need the printed version, or at least an electronic version of the full document. As you may recall from contracts, every section in this book, every code section in this book has a comment. And those official comments, while not law, are very helpful in understanding how the statute works. And in Article 9, they really are terrific. They give examples, they explain why a law, the policy behind the choices that they made. The Cornell site, which I use a lot because it has Article 9 on there, has the entire Uniform Commercial Code, has no comments. And so you will miss out on understanding how the statute works if you don't have a copy that has the comments in it. Now, there may be electronic versions that have that. Whatever. That's fine with me. But you need the comments to really get it. Okay? I'll give you an example. Article 9 has a kind of collateral called a general intangible. General intangible is the catch-all. If it doesn't fit into any other category, it has to go somewhere. It's a general intangible. So if it's an account with a bank, it's not in there. It's a deposit account, right? Even though a bank account is kind of intangible, it's not a general intangible. It's a deposit account. Where are copyrights? There's no section in here that describes copyrights. They're general intangibles. How would I know that? The comments describe that copyrights, patents, and trademarks are a form of general intangible. And I would only know that if I had the comments. So it's important to be able to read the comments that go with the sections. Questions about the book, about versions of the code. By the way, the code hasn't changed in the last few years, so I'm not particularly interested in you getting the latest version. I think you're probably pretty safe if you have something from 2014 after, maybe even 11. I don't remember if there's anything. Article 9 hasn't changed since then, but I don't know if the code was, the bankruptcy code may have had a couple of small changes. Probably not even relevant to this class, but there have been changes. So if you have a used version that someone else annotated and it says 2017 on it, totally cool with me. Yes?
Are you able to use this on the exam?
Yes. You will not be able to use it on the bar exam, okay? So I'm actually not giving you full bar exam, but my reasoning behind that is no lawyer who is worried about being ethically correct in how they do things would ever do an analysis without the statute in front of them, because it's impossible to have memorized the whole thing. So I like you to have access to this because I think that's how lawyers actually use this. So I want you to think that way. The bar exam's not quite that nice. They're testing sort of minimum standards, but that's not, I sat with this thing open at my desk. I mean, I do it to this day when I'm writing articles like this. I have this sitting in front of me so that I know what I'm talking about. Because, I mean, unless you have a photographic memory, there's a lot of stuff in it. So, on the bar exam, you will have access to this. I have not decided yet but there's a chance. I'm trying to use Blackboard because I'm trying to see if we can do this all online. And the grade book that's available in Blackboard, you cannot take an anonymously graded exam in exam 4 and easily transfer those grades into Blackboard without somehow someone looking at the exam number and translating the name. But Blackboard has an exam piece of software built into it called Respondus Lockdown Browser or something. I'm going to talk to them over the course of the semester, see if it works for this class. I may not use exam 4, I may use that exam technology, and then I would grade entirely on the laptop. So your exam would be submitted electronically, I would grade electronically, your grade would show up in Blackboard, and then it's posted right to ULink. So it's how we're doing, it's how the university is doing online classes now, and we're trying to see if this works for the law school. I haven't decided about that yet, so the instructions in there are about exam 4. If I do use Respondus, you don't have to do the practice test for exam 4 for this class, because that's software provided by the university, and it should work on everybody's computer. I have talked to Jim Becker about what happens if somebody has a problem with their computer, or if they don't have a computer, they don't have a laptop, which very rare today. Almost everybody produces a laptop for their exams. We probably will have available a few Chromebooks, which would be fine for doing the exam if we do it that way, okay? I haven't made that final. I included the exam 4 instructions in here, but I may change the syllabus to reflect a different way of writing the exam. It won't change the exam, it's just where you'll write, that's all. All right? Questions about anything that I posted on any of the videos? Any moral outrage that someone would take somebody's bed? Yes, terrible, right? Since we only meet once a week, did I bring it with me? Shoot, I didn't. So next class, I will do a seating assignment. I'll send that around, so next Wednesday. So if you decide you want to sit somewhere else between now and then, feel free to move, and then I'll send around a seating chart. All right. Good. Well, let's talk about before we go to the presentation, I thought we should work through the let's work through those definitions. Did everybody find a definition for every word? There's at least one word in there you should not have been able to find a definition for. Which I think, when we talk about the word, it's kind of funny that that word is not defined. All right. All right, so where do we define the definition for security agreement? Oh, shoot. I'm supposed to hide that. Oh, there we go, video. All right, give me the answer. Oh, you know what? Here, this is all. Just to show you, I mean, it's great. I mean, it's all right here. I love it. Easily accessible, no comments. So it's not helpful. Okay, what section gives us the definition for security agreement? Just yell it out. 74. 74. Okay. scroll down. I was trying to use links, and the way Cornell does the links, the internal links to the web page, you can't see them. So you click on a link, and then the definition is up too high, so you can't read it. It's really stupid. Security agreement. An agreement that creates or provides for a security interest. Okay. What's interesting about that? What's interesting about that? I think what's interesting is it uses the word agreement. What does agreement suggest to you? It's a contract, right? So the first thing we have to understand is that we're talking about contracts here. And in fact, a lot of what we're going to do is understand how a particular kind of contract operates and the rules that govern the language of that contract. Now, can you be forced into a contract? Technically, no, right. So that tells us something else about Article 9. It's about consensual agreements, right? It's not about things that happen and you didn't agree to it in advance. So that's also very useful, I think, right? So we're talking about contracts, and that means we're talking about agreements that we enter into voluntarily. Now, does that mean everybody understands what they enter into? Did you read the end user licensing agreement for the software on your computer?
I do not.
Okay, so are there terms in there you don't know what they say? Okay, so the fact that the person doesn't know what the contract says doesn't mean that it's not voluntarily entered into. They just chose not to read it. So can you accidentally get into a security agreement you didn't know was a security agreement? Yes, of course. But that doesn't mean you didn't voluntarily ignore what you should have known about, right? So it's consensual in the sense that you voluntarily did it, but you didn't do all the research you should have done. Well, okay, that's on you, right? And remember, we're talking about a statute that deals with property rights, personal property rights. So you can create rights in other people that you don't fully understand. That does not make it non-consensual. A tort is a non-consensual act, right? When somebody commits negligence against you, you didn't voluntarily do that. You got hit by accident. You don't enter into contracts by accident. This is all agreed upon. All right, what's the second definition? What was the next one?
Did we skip security?
Yeah.
Did I do this out of order? Sorry. See, I was so worried about you not seeing the okay. See, negligence. See, it's good that we talked about negligence because that was negligent teaching, right? All right, let me pull them up on here. This will just take a second. Sorry about that. But that's okay because the definition says security interest. So what is a security interest? What section of the statute governs security interests? Oh, everybody's so shy. Just yell it out. What article is it? Is it Article 9? What article? Okay, and what section of 1? 201. In which subsection of 201? B35. Okay. All right. And here we go. Let's see if this downloads. Oh, you know what? I did it out of order. That's why it's different. Okay. That's on me. All right, so let's go to Article 1. Commercial code. Article 1. All right, security interest means an interest in personal property or fixtures which secures payment or performance of an obligation. All right, so I did those backwards, that's on me, sorry. Security interest means an interest in personal property or fixtures which secures payment or performance of an obligation. Payment or performance of an obligation. All right, well, what's an obligation?
Well, I couldn't find the definition.
You couldn't find a definition of obligation? Not, well, what is an obligation? If you can't find it in the statute, where would you look?
Dictionary.
Yeah, Black's would be a good source. Preferably, if you're in a court, you would look for a case that has defined it, if you can find that. Otherwise, Black's is probably a pretty good source of a definition. Okay. Is it in the back? Was it in the Bankruptcy Act?
I couldn't find it. That doesn't mean it.
All right. Well, let's go to the Bankruptcy Act. Give me a tab and get the law. It's code. Title 11. You wish that people who drafted statutes would use the same numbering for all these things. Why isn't it always section 101 that is the definition section of every statute? It's 9102 in Article 9, and it's 1201 in Article 1. Please, make these things consistent. You went through this, you didn't find it in here either?
I didn't, but
So, the way I cheat when I'm doing these things is Control F,
yeah.
right? Obligation. It comes up, right? Obligation, obligation, obligation. The term lien means a charge against or interest in property secured. Wasn't lien one of the ones that I asked you to look up? Okay, so here we have lien, definition of lien. Performance of an obligation, obligation, obligation. It's all over the place. In Article 9 too, it's not defined. Okay, good. So what's an obligation? If we don't find it in the statute, well, let's define it. What should be our definition of obligation? Yeah.
An act or course of action to which a person is morally or legally bound.
Okay. The morally part is interesting. Do we enforce moral obligations? Okay, so we're probably not talking about moral obligations. We're talking about legal obligations. So what's a legal obligation that probably would be talking about here in a course on secured transactions? What? I heard somebody said it. A loan, right? So a debt, right? A debt. We'd probably be talking about a debt or something like that. Okay. So the obligations that we care about, not exclusively loans though, just so you know, right? The term obligation is broader than the word loan. So it is conceptually possible for the obligation to be something that is not a loan. A transaction could also include an obligation that is, say, rent, right? It just means that in order for there to be a security interest, there has to be an obligation that you owe, okay? Good. So we've done security interest, we've done security agreement, we've done obligation. How about obligor? Is that defined? So who's an obligor? Micah, what section of the statute is it?
UCC 9.
Article 9, so we'll scroll up and we find that obligor is, in fact, a person that, with respect to an obligation, non-defined term, secured by a security interest in or an agricultural lien on the collateral. This is a handy thing about the Cornell site is they do hyperlink. See, look, I hyperlinked. Can you read the definition of agricultural lien here? No, you got to scroll up to it. Agricultural lien means an interest in farm products which secures payment or performance of an obligation for. All right, we're not going to do a lot with agricultural liens, but they are a form of security interest. they're generally transactions that relate to farm products. Let's go back to, see if this will take me back. So obligor person then, with respect to an obligation secured by security interest, owes payment or other performance of the obligation, has provided property other than the collateral to secure payment or performance of the obligation, or is otherwise accountable in whole or in part for payment or performance of the obligation. Okay. So what do we think obligor is then? Who is this person? They're a borrower, yes. I think that's a great way of putting it. They're the person who owes the money. And since we're usually talking about loans, not exclusively, but mostly, it probably is the borrower. The term does not include issuers or nominated, don't worry about that last part, okay? So when we're talking about the obligor, we're talking about the person who owes the money, okay? What was the next definition? Because I hope I did debtor next. Did I do debtor next? Secured party, and then I did debtor. Okay, who's the secured party? Is that a defined term? Also in this statute? So we scroll down to secured party. 72. 73.
Sorry.
Means a person in whose favor a security interest is created or provided for under a security agreement, whether or not any obligation to be secured is outstanding. And remember, what's a security interest? Go back to Article 1. Security interest is an interest in personal property or fixtures. We'll talk a little bit about fixtures. I didn't ask you to look up fixtures, did I? No. Fixtures are personal property that are attached to land. This is a fixture because it's permanently, well, this isn't permanent. Like this phone is now a fixture because it's permanently attached to the wall. The lights are fixtures. Personal property attached to real estate. Security interest is an interest in personal property or fixtures which secures payment or performance of an obligation. So the secured party is a person that has a security interest, which means that they are the person who was granted the security interest. So normally, if the borrower is the obligor, who would the secured party be? I'm picking on you because you're.
Sorry, obligating,
Who would that be?
the lender.
The lender, the bank. Doesn't have to be a bank, usually is a bank in this class. So the secured party is the party that has the interest in the collateral. The collateral is the personal property. And we will look up the definition of collateral in a minute. So this is the person who has the security interest. Since these are all agreements, it means you contractually agreed as the borrower, well, we'll come to debtor in a second. The person who signed the security agreement gave, by contract, a security interest to the secured party. Okay? And it's usually the bank. Doesn't have to be the bank, doesn't have to be a bank, but it's always the person who is usually is the lender, right? The person who is taking the security interest. All right. So let's look up debtor. Where is debtor defined? Subsection 18?
28.
28, okay. Yeah, because that's C. A person having an interest other than a security interest or a lien in the collateral, whether or not the person is an obligor. What do you think that means? Whether or not the person is an obligor. Why is that?
So if my parents co-sign on a loan for me, they are the obligor, I guess. They're the ones that will owe the debt if I fail to sign, but I have received the money, but I don't have to repay. They're the one that have provided the collateral.
All right, everything you've said is correct. You've missed the part where someone is a debtor.
The debtor.
Everything you've said is correct, but you're missing look at this again. Who is a debtor? The person having an interest in the collateral. So who is the debtor in our loan transaction? What's your relationship? If you're the debtor, whether or not the person is an obligor. Can you be a debtor and not an obligor? Yes. So who is the debtor?
The co-signer would be the debtor.
No, because if they owe the loan, then they're an obligor, right? So who's the debtor?
Person who has the property.
Yes, the person who owns the property on which the security interest is created. Do you have to own the money to be a debtor? No. So your example's a very good one, but a better example would be you sign the loan and they give a security interest in, the easy example is the mortgage. They give a mortgage in their house. You don't own anything. So you can't give a security interest in anything because you have no assets. The bank asks somebody else to pledge assets. You know, that could be your parents. So let's say they own some stock and they say, yeah, we'll secure this loan by giving the bank a security interest in the stock. Article 9 separates out the obligor from the debtor. That is not how the bankruptcy code does it. I just point this out because there is a debtor. Oh, let me just do this. I could type debtor. The term debtor, so subsection 13 means a person or municipality concerning which a case under this has been commenced. So they're the person who has filed for bankruptcy. Now it's interesting. There's actually a definition of debt in here. Maybe I'm wrong. Where is it? It's at the top. Person, entity, bankruptcy claim. Debt. The term debt means liability on a claim. I'm jumping a little around here. So the Bankruptcy Code and Article 9 do not have similar definitions of debtor. Debtor is the person who is the bankrupt, for lack of a better word. So if you file bankruptcy, you're the debtor. Okay? You're the person asking for protection under the Bankruptcy Code. You're the debtor. That's not the Article 9 definition. The Article 9 definition is you're the debtor if you own the property to which a security interest has attached. Okay? So this is going to be important. There are going to be sections in the statute that apply to the person who owes the money, and there's going to be sections in the statute that applies to the person who owns the property. They're not necessarily the same person. Now, are they normally the same person? Yes. Normally, the person who owns the property is the debtor, and the person who owns the person who owes the money owns the property. Right? That's usually true. Right? It's usually the same person. It does not have to be. The rules are different. Different things apply to the debtor and the obligor. I put my there. The university would be sad if I lost this thing. I just gave it to me. It's like the most exciting thing that happened to me all year. I got an iPad from the university. Okay, I showed you debt. Debt is defined in the Bankruptcy Code. Creditor, where's that defined?
1201.
Going back to 1201?
13.
All right. Includes general creditor, a secured creditor, a lien creditor, and any representative of creditors, including an assignee for the benefit of creditors, a trustee in bankruptcy, a receiver in equity, and an executor or administrator of an insolvent debtor's or assignor's estate. This is, I think, fairly similar to the concept of creditor in the Bankruptcy Code. Creditor is somebody who's owed money. Or say that differently. Creditor is the person who extended credit to somebody, but a creditor doesn't have to be consensual, right? In bankruptcy, creditors include people who are owed money for torts, for example. So since we're talking about, how about lien creditor? Where's that? So we talked about, I showed you lien earlier. Where's lien creditor? What section, which article has lien creditor in it?
11.
9? Article 9?
102. A50.
We'll look up. Lien creditor. A creditor that has acquired a lien on the property involved by attachment, levy, or the like. What's a levy? And it's not the thing that you build to prevent the river from overflowing, because that's spelled with 2 E's at the end, isn't it? Yes. So what's a levy? Anybody know?
Fine.
Can be. For our purposes here, it's usually the security interest that is created when a sheriff seizes goods. Sheriff, from once you file, get a judgment lien on somebody and you send the sheriff out to get the property, the levy is the act of the sheriff levying on the property. Okay? For our purposes, lien creditor, a creditor that has acquired a lien on the property involved by attachment, levy, or the like. Are those consensual situations? No. The lien creditor is a person that gets a lien. What's a lien? An interest in a security interest in property. A right to receive repayment of a loan or an obligation from property. The person who becomes a lien creditor is someone who got it not by a consensual agreement. Because if it was a consensual agreement, what kind of agreement? What would it be? Security interest. So we distinguish between lien creditors who get their interest through things like bankruptcy or a judgment, and secured parties who get their interest in the property by agreement through a security agreement. And that's a very important distinction. We will study this particularly at the end of the semester when we're talking about priority battles. Who gets paid first depends on who they are and how they're defined. Lien creditors get paid after secured parties, usually. There are some issues there. We'll look at the distinctions. But lien creditor is not the same as secured party. Okay? Now, casually, in common parlance, people will talk about mortgages being liens, right? So, sometimes the language that we use in this class has a very specific legal definition that is not consistent with the ordinary definition of the word. You've seen that in the law all the time. Lien is one of those. The common idea of a lien is just an interest in property. For Article 9 purposes, it's a lien that's obtained this way. Okay, one of these 4 ways. And that's important. And it's not a security interest. They're not the same. But when you talk to people and you go, hey, does somebody have a lien on your personal property? What they're probably talking about is a security interest, because that would be one that you would agree to. All right. We're coming to the end here. What was the next one? For some reason the camera's not. Secondary obligor. Okay. Your hypo earlier about your parents co-signing on a loan? Secondary obligor. It's somebody who's not the primary borrower, it's somebody else. But they have an obligation, they're entitled to be considered for purposes of repayment. Okay, this class goes till 12:05, so I have a short presentation I'm going to do. I'm never going to do this again because all of the PowerPoint presentations are going to be online, but for this class I'm going to finish up just with a short overview of how this works. And now that we know some of the words, this presentation will make more sense. So, but there was a question. So somebody had a question. Yeah.
So in that situation, so I would be the primary obligor, my parents would be the secondary obligor, and they would also be the debtor?
If they own the property.
If they own the property?
Yes, but you would not be a debtor. Unless you file bankruptcy, and then you would be a debtor. Okay, that's got to make your brain hurt. Okay? If you file for bankruptcy, you're the debtor. If you don't own property in Article 9, you're not the debtor. Okay? So, when I ask a question, and I say debtor, if I'm being a little loose with the language, and I'm not saying that if the person who owes the money also owns the property, then debtor is correct, because they're both the debtor and the obligor. And typically in this class, people will talk about debtors, meaning debtor and obligor simultaneously, okay? Because that's usually how it happens. Banks don't borrow money from lend money to one person and then go over here and say, hey, you got some land I can use, right? It's usually the person who's borrowing the money who's giving up the property to secure repayment. Okay, security interest is a relationship between a debt and an asset, which we refer to as obligation and collateral. So we've talked about that already, right? I'll post this, don't need to take notes. But the key here is that these rights that the secured party has, the security interests, are related to when a debt is not paid when due, right? If the debt is not paid, then they can take the money, take the property to pay off the loan. All right, the process where you do that is called foreclosure. So you studied that probably a little bit in property law. Foreclosure is the process where we take property and use it to pay off an obligation. All right. So that makes this a contingent right in the property. The secured party can't come to your house and go, hey, I lent you a bunch of money, I want to use your pool. That's called trespass. Just because they have a mortgage doesn't let them go onto your property. Their interest is contingent on you not fulfilling your obligations under the loan or the mortgage. Okay, so contingent on non-payment. And again, it's consensual. The example we did, mortgage, lien. Okay, so let's talk a little bit. I have some examples here of security interests, and again, the bankruptcy code and Article 9 are not exactly identical. Security interest is a defined term in the bankruptcy code too. I don't know if you saw that when you were looking these things up. Security interest in the bankruptcy code is any of these interests, but it can be real estate, right? We're going to look at this for next week, but Article 9 does not cover real estate transactions. It just does not. But a security interest can include real estate because the bankruptcy code says so, right? So the kinds of things that are collateral are all of these, and they all fall into different kinds of categories. So chattel paper, we'll study that. I'm not going to define it right now. But these are all things that can be collateral. And the problem with them is they don't fall into the same category, so the rules are different. And this is one of the skills you're going to have to learn is to go, oh, what is this? It's a copyright. That makes it a general intangible. That means I can only perfect my security interest by filing a financing statement. And to foreclose, who knows? I guess I got to go to court. But all of that starts with knowing that copyright is defined as a general intangible. Okay? They're not the same. We will look at a lot of these. Is a lottery ticket collateral? It can be. It's worth money. Maybe. Okay, so the different kinds of loans that we're going to look at. So these are the kinds of loans that are going to be in this class. Home loans, auto loans. We're going to talk about home loans mostly only as examples because real estate is the system that existed before Article 9. So mortgage and real estate law is a thing to look to as an example. But Article 9 applies to personal property. It does not apply to real estate. We're going to talk about purchase money obligations. We may look a little bit at corporate bonds, and maybe not. Purchase money, somebody lends you the money so you can buy something. Special rules for those kinds of loans. Okay. Guarantees. So just describing a typical corporate kind of transaction where we have a security interest. I'm sorry, can you guys see this okay over there? So shareholder is the person who owns the corporation, okay? Corporation borrows money, grants a security interest. They borrow money and they grant a security interest in the property of the company. Shareholder in a small corporation may be asked to give a guarantee. Very common for closely held corporations. That the owners of the company, even though they're not legally obligated on the loan, it's the corporation's loan, the bank says, hey, we're not so sure your company's solvent. We want a security interest in your property too. So if they don't owe the money, but they own the property, if they don't own the property, but they owe money, what does that make them? They don't own property, but they do own money. They're an obligor, right? Debtor and obligor, only an obligor, okay? All right. Now, if they grant a security interest, they become a debtor as well. Okay. So let's just distinguish between consensual liens and non-consensual liens, and statutory liens. So the typical examples of security interests that are consensual are Article 9 security interests, mortgages, and there are other examples of non-Article 9 security interests. We're not going to cover them, but they do exist. Statutory liens are liens that exist because the law says they come into existence automatically when something happens. They're called mechanics liens often. So you take, and the reason it's called a mechanics lien is you take your car to a mechanic and you leave your car there. Costs you $1,000 to get the radiator fixed. You don't pay. Mechanic has an automatic lien without doing anything in your car for the $1,000. And these are various, different states have different rules. Sometimes dry cleaners have security interests in the clothes that they cover, right? Many examples of this. I think I have a few. So agricultural liens, mechanics liens. Tax liens come into existence automatically when you don't pay your tax. Anybody here own real estate? Who pays the tax on your house? Do you pay it or does the bank pay it?
Oh, the same, we escrow it.
Yeah, why do you escrow it? Do you know why?
Because they make you.
Yeah, but why do they make you? They make you because tax liens jump ahead of every other security interest. Tax liens jump to the front of the line. So the bank says, I like you, I don't trust you. Give me your money, I'm going to pay the tax so that my security interest, the mortgage, does not get lower priority than the tax lien. And tax liens, the IRS doesn't have to do anything. They just get them. It's good to be the government. I'm just giving you other examples here of kinds of organizations that get automatic liens by statute. All right. Compare that to judicial liens. So a judgment lien, unsecured debt, say a tort, you sue the person, you win $1 million. Does the $1 million judgment by the court guarantee payment? No, and I think this is the thing that shocks most people who are not lawyers. You win your case, and then you say, when do I get paid? And the lawyer says, I don't know. It's like, well, why did we bother? Well, the way you get paid if the person doesn't pull out a checkbook is through a judgment lien. And you go back to court and you say, they haven't paid. I want to put a lien on their house, on their car, on their TV, whatever, however the court might allow it to happen. And they get a judgment lien. Again, non-consensual. Non-consensual, non-consensual. This happens by operation of law. This happens because a judge issues a ruling. And there are different versions of this. If you are suing somebody and they don't pay and you get a judgment against their wages, does anybody know what that's called? Garnishment. Yeah, you can garnish somebody's wages. That's a judicial kind of lien on their income. See, it was the next one up there. Okay. So, now, I didn't set this up, but I like this. Another professor said that this is a map of how these things all tie together, right? And I'm not asking you, you're not going to be able to write this all down. I will post this. But the idea here is understanding the different relationships with the statutes that are involved. So we have a lien. It's an obligation that connects it's a right that connects an obligation to collateral. So if somebody doesn't pay, the bank has a contingent right to take your collateral to pay off the loan. Okay? The creditor and debtor are referred to lienor and obligor. And the obligor is somebody who has rights to the collateral through the obligation by operation of the lien. Okay? But it's a contingent one. You don't get it automatically. You can't just take their property. You have to foreclose. Now the cool thing that we're going to see about Article 9 is you don't have to go to court to foreclose. You can, you don't have to. If it's an unsecured loan, you have to go to court to be able to take the property. Otherwise, it's theft. So foreclosure is the process of taking the property to pay off the debt. Okay? What do you do if there's a deficiency on the debt? You sue the debtor for more money. But not in every state. In some states, you're not entitled to obtain deficiency judgment. Okay? Depending on the kind of loan. So, how much does the bank get? It depends on the value of the collateral, right? So if the value of the collateral is worth less than the loan, that creates a deficiency, which then allows for a lawsuit. Oh, I jumped ahead there. Okay? So, again, lien connects collateral to an obligation. The obligor and the debtor have agreed that this collateral is going to pay off the loan, but you can only get it through foreclosure. This obligation doesn't just include the original loan, it can also include future loans. It could be a floating lien. It could be, I'll give you, whenever I give you money, when the bank says, whenever I give you money, I can seize your property to pay off the loan. The lien can cover property that was acquired after the loan was entered into. That's called after acquired property. So it's sort of the flip side of future advances. The bank can lend more money and it's covered by the lien, but the debtor can buy more property that can be covered by the lien. And that's covered under something called after acquired property. Now, before we go any further, is this a consensual or non-consensual situation? Consensual or non-consensual? Consensual, right? We talked about this right at the beginning. None of this happens without the agreement of the parties. So whether future advances are covered and whether after acquired property is covered is part of an agreement. If you're sophisticated, you will read the loan document and you will understand whether or not these things apply. Right? If you don't read the loan document, I can't help you. But if you read the loan document and it says it covers after acquired property, you can say, nope. You buy a car. Got 5 minutes. You buy a car. You don't pay. How's the bank going to seek repayment of the loan if you don't pay the debt off? Yeah, they're going to repo the car, right? Can they repo your TV?
It depends if you didn't pay for it and you loan money for it.
No, so assume that the TV is not part of the loan. It's only on the car. Will the car loan company take your TV? No. And nobody expects that, right? They expect that when you buy a car, the only thing that's collateral is the car. Now, if you're the bank and you're lending to GM, do you expect that there's an after acquired property clause? You bet 100%. Can they take the car? Sure. And they can take the machinery in the plant and anything they bought afterwards. But by agreement, because that's what the parties agreed to. And that's what the point I'm trying to make here. This doesn't happen by accident. You agree to these things. A consensual lien is created. Thank you. I didn't mean to. I don't mean to pick on people, but I think it's more fun if we're talking about it. What happens if the property's sold? Does the security interest continue in the loan, in the collateral once it's been sold? You own a car that has a loan on it. You sell the car. Does the bank get to take the car from the buyer? Why not? You bought a car, you stop paying. You sell the car to somebody else, you keep the cash, you run away to Mexico, whatever. You're out of the jurisdiction, they can't get you. Can the bank go after the car? Absolutely. Unless. And we're going to study when the unless applies. So the question we have in the statute that the statute has to answer is, does the lien continue in the collateral? All of these things are answered in the statute, by the way. Okay? When you got the cash for the car, can the bank go after the money that you sold the car for, right? Let's say the car's worth $10,000 and you sold it for $6,000. Can they get the $4,000? Yes, unless. And we're going to see there are circumstances when it's hard to get the cash. But usually the answer is yes. What happens if you bought the car and then you went to another bank and you said, I need more money? And they go, cool, we'll take a security interest in your car. Who gets paid first?
First one.
Usually. That is usually the correct answer. It's not always the right answer. That's a priority battle. We will study that in this class. The statute has an answer for how we figure that out. All right, so this is the system that sets up the obligation between the parties. In the case that we read for today, Hub Carpet versus Ratner, or Benedict versus Ratner, they talked about secret liens. And the reason why the account was not collateral for the loan that Ratner had given was because it was deemed to be fraudulent, right? And it was fraudulent because it was secret. And it was secret because there was no way to put anyone on notice of the existence of it. It's very hard to let somebody know that accounts, which are just these little slips of paper, people know that those things are subject to security interest. One of the great advances of Article 9 is it creates a uniform filing system for all of these security interests. So you create a system of documents that the public can check, and they go, oh, I don't want to lend to this guy. He's already given away security interest in his accounts. His credit's not as good, right? I'm not as likely to get paid. That public notice is really critical for this. And we're going to study when do we use the filing system. Okay? The expectation is if you file, other people can search the filing system and find the security interest, which allows them to know whether or not they want to lend to you. Or at least ask the question, how much do you owe, right? We talked about priority battles already. We have to figure out who wins. I did it. There's a minute left. Okay. All of the things that I have put on here, we will study over the course of the semester. So the first thing that we're going to study next week is, does Article 9 cover this transaction? Okay. We've seen by the definitions that Article 9 covers security interests in personal property. But we're going to see that it's not every form of a security interest in personal property. It's only the ones that are covered under Article 9 as defined in the scope section, which is 9.109. So for next class, the question we're going to answer is, does Article 9 apply? And if Article 9 does not apply, it's a whole other ballgame. With 30 seconds, the point I want to make here is, sometimes Article 9 kind of applies. So the filing system is something that is not Article 9, but the loan itself is covered in part by Article 9. We're going to see there are circumstances where the filing system is taken out of Article 9, but Article 9 governs the rest of the relationship between the parties, like who has priority. That's determined by the priority rules of Article 9. Okay. Tons of really excited expressions in this room. Everybody really thinks this is going to be the best class they ever took, ever. I mean, I'm including undergrad here. Okay. Maybe you liked your French class, or your psychology class.